Okay, let's unpack this. We are diving into one of the most foundational, complex, and frankly, most contested concepts of any political community, citizenship. And today we're focusing specifically on India.
That's right.
Our listener shared sources that are, I mean, they're essentially detailed legal roadmap. It's a guide to what it means to be a recognized member of the Indian political community.
hmm
And it covers everything, right? From the moment the Constitution began all the way up to the latest, often, intensely debated amendments.
And we should be clear from the start, this isn't a political debate.
No, not at all.
This is a deep dive into the legal architecture itself.
And that architecture is crucial because the stakes here couldn't be higher. I mean, citizenship isn't just a fuzzy feeling of belonging.
No, it confers specific, defined civil and political rights, rights that are explicitly and constitutionally denied to those classified as aliens, as non-citizens.
So it establishes this fundamental legal division from day one. It creates clear advantages and disadvantages.
It absolutely does.
What I found immediately fascinating, as we were going through the sources, is that you can't get the full picture by reading just one document. It's a dual framework.
Exactly. The law of Indian citizenship requires you to read two main bodies of work. First, you have the foundational document, Part 2 of the Constitution, specifically Articles 5 through 8.
And these had a really specific job, right?
A very narrow, very critical mission. They were there to define the initial classes of people who would be citizens at the precise moment of commencement. That's 26 January 1950.
The starting line.
It was the starting line, a snapshot in time, really, designed to address the immediate aftermath of independence and, of course, partition.
So the Constitution sets the initial conditions, but it doesn't write the rule book for the future.
That's the key. The Constitution explicitly delegated the rest to Parliament. And that brings us to the second body of work.
Which is Parliament's response.
Parliament's response. The Comprehensive Citizenship Act of 1955. This act manages everything that happens after 1950. All the rules for acquiring, for maintaining, and for losing citizenship. So our mission today is to break down that detailed legal division, really understand those initial commencement rules, and then trace how that 1955 Act has had to evolve constantly.
To meet changing demographics and social realities, okay, let's get into it. Let's start right where the law starts, this fundamental divide. Why is this definition of citizen so critical? The sources make it crystal clear that the state's population is split into two classes, and that split dictates everything.
It is the most profound division any sovereign state can enforce. Citizens are, by the Constitution, the very members who compose the state. They enjoy a monopoly on specific constitutional rights and privileges.
Rights that are necessary for full political and judicial participation.
Exactly.
And when we talk about rights, we often discuss the fundamental rights. Many of those apply to every person in India, citizen or not, but there are some really critical ones that are reserved only for the citizen.
And the sources point us to three major constitutional articles that draw this hard line. We have to focus on Articles 15, 16, and 19. If you are classified as an alien, you are expressly denied the protection of these specific articles.
Let's just talk about the impact of that for a second. Article 15 prohibits discrimination on grounds of religion, race, caste, sex, or place of birth.
Right.
And Article 16 guarantees equality of opportunity in public employment. I mean, those are immense protections for citizens.
They are massive, yes. But the one that perhaps most immediately impacts public life is Article 19. This is the bedrock of democratic freedom.
This covers freedom of speech and expression.
Speech and expression, the right to assemble peacefully, the right to form associations or unions.
The right to move freely throughout the territory of India, practice any profession.
All of that. So denying Article 19 freedoms to aliens, it drastically limits their ability to engage publicly, politically, or economically in the same way a citizen does. It basically confines their role to the private sphere.
That makes perfect sense. If you are not entitled to assemble or speak freely against the government, your political role is fundamentally curtailed.
It's gone.
But the distinction goes much further than just freedom of expression. It defines who can even hold positions of constitutional authority.
Oh, absolutely. The list of high offices reserved solely for citizens is exhaustive. It's explicit in the Constitution. The intention is clearly for citizens to be the exclusive holders of state power.
So instead of just dryly listing every article number, let's just use some of the most impactful examples. It really underscores the breadth of this restriction.
Well, the ultimate symbolic head of state, the president, must be a citizen. That's stipulated right there in Article 58(1)(a).
Okay, so the top job.
The top job. And likewise, the vice president, as per Article 66(3)(a). So no foreign national can even symbolically head the state.
And what about the judicial system?
The integrity of the judiciary is also protected for citizens only. Judges of the Supreme Court, that's Article 120d(4)(3), and judges of the High Courts, Article 217(2), must be citizens.
So the entire upper judiciary.
The entire upper judiciary.
Yeah.
And this exclusivity extends to key legal and state representatives, too. The Attorney General, the Governor of a state, the Advocate General. Essentially, if the position involves interpreting or exercising sovereign state power, it is reserved for a citizen.
This means the entire separation of powers, executive, legislative, and judicial, is completely manned by citizens.
It has to be.
And of course, the most basic democratic participation, voting and holding a legislative seat, that's also exclusive.
Precisely. The core political rights are confined to citizens. The right of suffrage, which is just the right to vote, for elections to the House of the People and the State Legislative Assembly, that's secured under Article 326.
And the flip side of that coin?
The reciprocal right to become a member of Parliament or a state legislature. That's governed by Article 84 and Article 191, Tyler. So if you can't vote and you can't run for office, you are functionally removed from the democratic process.
That's a really comprehensive picture of the huge legal advantage of being a citizen. But then the sources introduce another layer of complexity. It's a line not just between citizen and alien, but between a friendly alien and an enemy alien.
That distinction really highlights how deep national security concerns are woven into the legal fabric. Now, all the rights we just discussed are denied to all aliens, friendly or otherwise.
Okay.
However, the enemy alien suffers from a specific critical legal disability that friendly aliens do not.
And what is the practical implication of this special disability?
It relates to procedural justice under arrest. An enemy alien is not entitled to the benefit of the procedural provisions relating to protection against arrest and detention, the ones you find in clauses 1 and 2 of Article 22.
Wow, that is a huge loss of protection. Article 22 is fundamentally about due process. The right to be informed of the grounds for arrest, the right to consult a lawyer, the right to be produced before a magistrate within 24 hours.
All of that.
So stripping those protections away allows for much broader, potentially indefinite detention without the usual judicial oversight.
It removes the most basic checks on state power during detention. And the definition of an enemy alien is broader than you might think. It's not simply about the nationality of the individual.
And that's where it gets truly fascinating. The category isn't confined merely to subjects of a state with whom India is currently at war.
No, it extends further. An enemy alien includes subjects of a state at war with India, but also, and this is critical, it encompasses Indian citizens who voluntarily reside in or trade with such a state.
So an Indian citizen, by choosing to associate or trade with a state that's deemed hostile, can legally compromise their own status.
They can effectively become an enemy in the eyes of the law,
even if they haven't formally lost their citizenship yet.
It's a powerful illustration of how loyalty and association are factored into the state's relationship with its members. It shows that even allegiance, not just your passport, can define the level of protection you receive under the Constitution. It's a legal status defined by perceived threat.
That sets the stage beautifully for our next section. The Constitution, having defined what rights a citizen has, then had the monumental task of deciding who got those rights on day 1, January 26, 1950. And here's where it gets really interesting, because the rules had to deal directly with birth, domicile, and the monumental human catastrophe of partition.
Right. And as we stressed earlier, the Constitution wasn't trying to create a permanent forever law. It was fixing the population for that precise moment. Articles 5 through 8 were like the surgical instruments used to define who crossed the finish line as an Indian citizen on that commencement date.
And then it left the rest for the 1955 Act.
Exactly.
Okay, so Article 5 seems to be the broadest one. It sets up 3 main criteria, all rooted in this concept of domicile in the territory in India. But before we dive into those categories, we need to quickly clarify what domicile actually means here. Conversationally, it's not just residence, is it?
No, and that's an essential distinction. Domicile is much more than just mere residence. Residence is your physical presence.
Yeah.
Where you're living. Domicile is about that physical presence combined with the intention to reside there permanently.
So it's your legal permanent home.
Your legal permanent home. For the purpose of Article 5, it meant having your permanent home within the defined territory of India on 26 January 1950. It's a state of mind as much as a physical location.
Okay, with that clarified, let's look at the 3 paths under Article 5. Path A seems like the purest form of birthright citizenship at commencement.
It was the most straightforward category, absolutely. Article 5A stated that every person who was born in the territory of India and was domiciled there became a citizen.
And this was regardless of the parent's nationality.
Totally independent of the parent's nationality. This established the principle of jus soli, the right of the soil, in that initial population snapshot. If you were born on the land and intended to make it your home, you were in.
Simple enough. Path B then broadened the net slightly, recognizing a parental connection.
Path B covered those who were domiciled in India, even if they themselves were not born there, provided that either of their parents was born in the territory of India.
Ah, so this is a nod to just sanguinis, the right of blood.
A critical nod, yes. It allowed children of Indian-born parents who just happened to be born abroad, maybe during a temporary absence for work or study, to claim citizenship if they had returned and established that all-important domicile. It was highly inclusive.
And then there's Path C. This seems specifically tailored for long-term settlers, people who might have had no ancestral connection to India at all, but had thoroughly rooted themselves by 1950.
That's precisely what Article 5C was designed for. It applied to persons who had their domicile in the territory of India and had been ordinarily residing there for not less than 5 years immediately preceding the Constitution's commencement.
That 5-year residency requirement is the tangible proof of commitment. What sort of situation was this designed to cover? The sources give an example, right?
They do. A very clear illustration which helps us understand the context of the time. This clause would cover, for example, a subject of a Portuguese settlement. Let's say that person had resided in India for at least 5 years right before commencement, with the explicit intent to reside there permanently.
They would be recognized as a citizen under this rule.
Exactly. It was about recognizing deep settled residency and the intent to integrate into the new republic, regardless of prior colonial or foreign connections.
Oh, okay, so these Article 5 rules covered those who were already settled. But the real legal challenge, the really tough part, came with Articles 6 and 7, which had to grapple with the chaotic human displacement of partition.
A monumental task.
How did the law manage migration from Pakistan?
So Article 6 was dedicated entirely to persons who migrated from the territory that now comprised Pakistan. And to even be considered, there was a baseline requirement. They, or their parents, or their grandparents, must have been born in India as defined in the Government of India Act, 1935.
The 1935 definition of India, why that specific act?
Because that was the last legal definition of undivided India. The pre-partition borders were the necessary standard of reference for determining those historical ancestral ties to the land.
And the sources highlight a really critical date that divides the rules for these migrants, July 1948. That specific date must have marked a major shift in policy.
It did. That date marks the moment the Indian government introduced a formal permit system for movement between the two new nations. The law differentiated between the initial spontaneous chaotic migration and the later, more controlled migration.
So if you migrated before that permit system was in place, before July 1948, the path to citizenship was relatively simple.
It was much simpler. For that group, they only needed to have been ordinarily residing within the territory of India since the date they migrated. No complex registration was needed. Mere continuous residency was enough to confirm their status at commencement.
But if you migrated on or after July 1948, the system became significantly more bureaucratic and proof-intensive.
Yes. For this later group, they had to apply before the Constitution's commencement for registration as a citizen. And crucially, they had to prove to the registering officer that they had already resided in the territory of India for like 6 months before they even made that application.
So it was a two-step process for them.
Mandatory residency plus formal registration under the new system. It shows a tightening of control, a move to manage who was allowed to settle permanently after the initial chaos had subsided.
And then Article 7 dealt with this very small, very specific group of people who initially chose Pakistan but then changed their minds and came back, the return migrants.
This is perhaps the most nuanced constitutional provision addressing the trauma of partition. Article 7 covered those who had migrated from India to Pakistan after 1st March 1947.
So they left India for Pakistan.
Correct, but then decided to return. To be eligible for citizenship, they couldn't just come back. They had to return under an official permit issued by the Government of India, a permit for resettlement or permanent return.
So they needed official sanction to come back.
Official sanction. And once they had that, they could be registered as citizens in the same manner as the post-July 1948 migrants. It was a regulated, formal path back for those who had made an initial choice but subsequently reversed it with government approval.
It's just clear the Constitution was meticulously trying to cover every conceivable scenario that arose from the largest mass migration in human history.
It had to.
To round out this 1950 picture, Article 8 addressed the diaspora, those who were overseas when all this was happening.
Right. Article 8 was there to ensure that the overseas Indian community, people who had definite roots but weren't physically present, weren't accidentally excluded. It provided for persons residing outside India whose parents or grandparents were born in that undivided India of the 1935 Act definition.
And how did they claim their citizenship?
They could secure their initial citizenship status by applying to the consular or diplomatic representative of India in their country of residence. They'd go to the embassy or consulate and apply for registration. It was the mechanism for claiming citizenship from afar at that point of commencement.
So 26 January 1950 sets the foundation. Everyone's status is fixed on that day. But then everything that follows, the living, breathing reality of citizenship law, is governed by the statutory authority of Parliament.
And that's the crucial transition. The Citizenship Act of 1955. This act makes elaborate provisions for 5 primary modes of acquiring citizenship after the Constitution's commencement.
And the evolution of these modes, especially citizenship by birth, tells a really powerful story about India's changing priorities around migration and national identity.
A very powerful story.
Let's focus on that first one. Mode 1, citizenship by birth. The sources show this remarkable legal shift, moving from a near pure jus soli right of the soil principle to an increasingly strict jus sanguinis right of blood requirement. Let's trace that journey.
It started very, very broadly. In the first phase, from 26 January 1950 all the way until 1 July 1987, the rule was overwhelmingly jus soli.
Meaning
Any person born in India was automatically a citizen by birth, period. The only minor exceptions were for children of foreign diplomats or those born in enemy-occupied territory.
Yeah.
Very specific legal anomalies.
So for almost 40 years, the place of your birth was pretty much the sole determining factor. But that changed radically in 1987. What was driving that first major amendment?
Well, the shift in 1987 was a direct response to growing public and political concerns. There were regional migration issues, particularly in certain states, and a feeling that the very open birthright policy was being, exploited.
Exploited how?
The concern was that jus soli was unintentionally facilitating illegal migration and permanent settlement. People were allegedly entering India solely to give birth and secure citizenship for their children, creating a new generation of citizens with no other tie to the country.
So the first tightening came in that period between July 87 and the next big amendment in 2003. What did that phase require?
The law began incorporating the right of blood.
Oh.
During this period, a person born in India was a citizen by birth only if either one of their parents was a citizen of India at the time of the child's birth.
So that's the compromise.
It's the legal compromise. It acknowledges birth on Indian soil, but now it requires at least one parental link to the existing political community.
And then came the most stringent change, the post-2003 amendment. This reflects really heightened concerns about the legal status of the parents themselves.
Absolutely. The post-2003 amendment introduced much stricter requirements. This was designed to tackle the issue of illegal migration more aggressively. A person born on or after the commencement of the Citizenship Amendment Act of 2003 becomes a citizen by birth only if they satisfy one of 2 criteria.
Okay, what are they?
Either 1, both of their parents must be citizens of India, or 2, one parent must be a citizen of India, and the other parent must not be an illegal migrant at the time of birth.
That second criterion is a monumental policy shift.
It is.
It means birthright citizenship is now explicitly contingent not just on parentage, but on the legal compliance of the non-citizen parent.
It's a deliberate move. It shifts the burden of proof and denies the automatic benefit of birthright to the children of illegal migrants. This change effectively completes the transition from a place-based system to a system that is heavily reliant on parental legal status.
Okay, let's move to mode 2. Citizenship by descent. This is for people born outside India. And this definition also saw a really necessary evolution toward gender neutrality.
Yes. Historically, from 1950 right up until 10 December 1992, the transmission of citizenship by descent was highly patriarchal.
How so?
For a person born outside India to be a citizen by descent, the father must have been a citizen of India at the time of the birth. The mother's citizenship alone was generally not enough to pass on the status.
But the law was amended in '92 to reflect changing norms.
Correct. For persons born on or after 10 December 1992, the rule broadened considerably. Now, either parent must be a citizen of India at the time of birth. This recognized the equal role of both parents in transmitting citizenship to their children born abroad.
Now, you mentioned something earlier you called the descent quirk. If a minor born abroad is a citizen of India by descent and a citizen of another country, there's a very strict requirement.
That's right, and this rule really underscores India's insistence on single citizenship. The minor must formally renounce the foreign citizenship or nationality within 6 months of attaining full age, so within 6 months of turning 18.
6 months, that's a tight window. What happens if they miss it?
If they fail to make that formal declaration and give up the other nationality within that short window, they automatically cease to be an Indian citizen by operation of law.
Wow, that seems incredibly strict. I mean, you can imagine an 18-year-old not being on top of their international legal paperwork. Is there any leeway there?
The legal sources highlight this as a hard deadline imposed by the statute itself. The intention is clear. Once an individual reaches the age of legal capacity, they must make a definitive choice. It reinforces the unitary nature of Indian citizenship. It places a really high degree of responsibility on the individual to manage their status proactively.
A profound challenge for the diaspora. Let's look at Mode 3, citizenship by registration. This is a path for people of Indian origin who don't qualify by birth or descent.
Right. Registration is the structured application process. It allows several classes of people to formally register. The key category is for persons of Indian origin who have been ordinarily resident in India for a specific extended period.
And that period is
7 years. 7 years immediately before making the application. This is to demonstrate a long-term, settled commitment.
And this path also covers personal connections, like marriage.
Indeed. It covers persons who are married to citizens of India. And also, critically, it provides a path for those OCI cardholders we'll talk about later.
How long does an OCI cardholder have to wait before they can apply for full citizenship by registration?
They have to meet 2 separate time requirements. They must be registered as an OCI for 5 years. And on top of that, they must have been physically residing in India for 1 year immediately before making the application. It's a mechanism to reward that long-term, legally compliant connection to the country.
Okay, Mode 4 is naturalization. This seems like the standard route for any foreign national.
It is. Citizenship by naturalization is the standard global mechanism. A foreigner, provided they are not an illegal migrant, can apply to the government of India for citizenship. This process has a strict set of requirements: residency, good character, knowledge of a recognized Indian language, and so on.
And finally, Mode 5, incorporation of territory. This deals with geopolitical changes.
A necessary legal cleanup provision. If India acquires any new territory through a treaty or a merger, the government of India specifies, usually through a separate order, which persons of that new territory will become citizens. It just ensures a seamless legal transition.
Okay, before we leave the 1955 Act, we have to touch on that special legal fix for Assam, the Assam Accord of 1985. This really shows Parliament's willingness to create highly bespoke rules for specific regional problems.
Section 6A, relating to the Assam Accord, is unique in the Act. It created a special set of rules for persons of Indian origin from undivided India who came to Assam from a specified territory.
And the eligibility was extremely specific.
Extremely. They must have arrived before 1st January 1966, and they must have been ordinarily resident in Assam since the day they entered. This was a direct political and legal attempt to resolve long-standing, very complex demographic tensions in the state.
It just showcases the immense flexibility Parliament has under the Constitution to manage citizenship after 1950. They can respond to regional crises with these very targeted, specific legal mechanisms.
And if we just step back for a moment and connect this detailed legal framework to the bigger political picture, we see a defining feature of India: single citizenship. This really stands apart from classic federal states like the USA or Switzerland.
Right, where they have a system of dual citizenship. You're a citizen of the U.S., but also a citizen of California or Texas.
Exactly. You're a citizen of the Federation and a citizen of the state or canton where you reside. India doesn't do that.
India is structurally federal, but citizenship is staunchly unitary. Why did the framers insist on this?
It was an ideological and a practical necessity, really rooted in national unity. You have to remember, India faced deep linguistic, cultural, and regional divisions at its founding. Providing only one singular citizenship, the citizenship of India, was meant to be a powerful binding force.
So all rights from the Constitution are claimed equally by any citizen, no matter where they were born or where they live.
That's the principle. There is no state citizenship that grants distinct or superior rights based on your geography.
And this unitary principle is directly linked to that concept of domicile we talked about earlier.
Correct. The Constitution, through Article 5, recognizes only one domicile in the territory of India. And the Supreme Court has repeatedly, forcefully affirmed that the legal system throughout India is one single, indivisible system. The very idea of a separate state domicile is rejected.
Because it's seen as counterproductive to the nation's integrity.
The Supreme Court has literally said that entertaining the idea of state domicile would be highly detrimental to the concept of unity and integrity of India. It could engender provincialism. When you move permanently from, say, Tamil Nadu to Maharashtra, your domicile remains Indian domicile. That's it.
So, if a citizen has the same fundamental rights everywhere, are there any permissible, narrow exceptions where your residence, not domicile, but where you're currently living, might give you a slight advantage?
Yes, there are two key exceptions that don't violate the core principle. The first involves state employment under Article 16.3.
But Article 16 is about equality of opportunity in public employment. How do they carve out an exception there?
So Parliament, and only Parliament, is empowered to legislate to require residence within a state or union territory for particular classes of, specifically, non-gazetted employment.
Lower-level government jobs.
Exactly. This is included to address genuine practical needs, like ensuring local knowledge or language proficiency for certain clerical jobs.
And the sources emphasize that Parliament is the sole authority here, not the state legislatures. Why is that distinction so vital?
It's the constitutional safeguard against provincial bias. State legislatures have no voice in this. By making Parliament the only authority, the Constitution aims to prevent states from creating laws that promote what's called invidious discrimination, unfair, malicious discrimination against citizens from other parts of India.
Has Parliament used this power much?
Historically, yes, with the Public Employment Act of 1957, but that law expired way back in 1974. So since then, the general rule holds: denying employment based on non-residence is largely impermissible.
Okay, and the second exception relates to educational benefits. We see this all the time with state universities.
This hinges on the specific wording of Article 15. Article 15 prohibits discrimination based on race, religion, caste, sex, or place of birth.
I see where this is going.
Crucially, Article 15 does not include the term residence.
The legal loophole.
It's the key legal loophole. Because residence is not a prohibited ground for discrimination, the Supreme Court has upheld the constitutional permissibility for a state to confer special benefits like fee concessions or reserved admission quotas upon its own bona fide residents in state educational institutions. The distinction between place of birth, which is prohibited, and residence, which is not, is everything.
That is a critical nuance most people miss. Now let's shift gears to a concept that seems to challenge this unitary nature of citizenship, although technically it doesn't. The Overseas Citizenship of India, or OCI, introduced in 2005, it is constantly mislabeled as dual citizenship.
All the time. It is the source of frequent confusion. OCI is a specialized legal status. It confers lifelong multiple entry visa benefits and some economic privileges, but, and this is the main point, it is not full citizenship. It does not grant the political rights we discussed at the start. No voting, no holding office.
Who is eligible for this OCI cardholder status?
The primary eligibility is for persons of Indian origin who migrated and acquired foreign citizenship. There are two conditions. Their host country must allow them to hold dual nationality in some form, and very explicitly they are excluded if they or their ancestors were ever citizens of Pakistan or Bangladesh.
And the scheme saw a major consolidation in 2015. The government merged the older persons of Indian origin, the PIO card, into the OCI scheme. Why?
It was for administrative streamlining and to enhance benefits. The 2015 Act formalized the shift to the Overseas Citizen of India cardholder status. The practical difference was significant. PIO cards only guaranteed visa-free entry for 15 years.
Whereas OCI is lifelong.
Exactly. OCI cardholders get a multiple-entry, multi-purpose lifelong visa to visit India. The merger granted those superior lifelong benefits to existing PIO cardholders and simplified the application process for everyone moving forward.
And that 2015 Act also significantly expanded the eligible population.
It did. The eligibility was broadened to include multiple generations and relational connections. New grounds included minor children whose parents are Indian citizens or OCI cardholders. It also covered spouses of foreign origin, subject to conditions. It even included great-grandchildren of a person who originally met the foundational citizenship conditions.
So they're extending the net deep into the diaspora.
It's a deliberate strategy. It's about engaging the diaspora by providing them with long-term, secure access to India without granting them the sensitive political rights of full citizenship. It's an economic and cultural connection scheme, not a political one.
Okay, so we've covered how citizenship is acquired. Now we have to address the flip side, how it can be lost. The 1955 Act provides 3 distinct legal mechanisms for the loss of Indian citizenship.
Right. And these 3 mechanisms are crucial for maintaining that unitary nature of citizenship and for national security. They are renunciation, termination, and deprivation.
Let's start with renunciation. This seems like the simplest one because it's entirely voluntary.
It is. Renunciation is a deliberate, formal act. It applies to a person who legally holds the citizenship of India and the citizenship of another country. For example, that minor we talked about who inherited both statuses. They can formally choose to abjure, to give up the Indian one by making an official declaration.
Simple enough. But termination is not voluntary. It happens automatically by operation of law. This is where India's single citizenship principle is enforced most rigorously.
Correct. Termination happens automatically the moment a citizen of India voluntarily acquires the citizenship of another country. India does not tolerate dual nationality for its full citizens. The act of acquiring a foreign nationality instantly voids the Indian one.
This leads to a really critical legal question about jurisdiction. If there's a dispute over whether someone acquired foreign citizenship, let's say the person denies it or claims it wasn't voluntary, who has the final say?
This is a highly specific legal centralization point, and it's vital for national consistency. The authority to determine whether a citizen has voluntarily acquired foreign citizenship rests exclusively with the central government under Section 9(2) of the Citizenship Act.
Not the courts.
Not the courts, and not a state government. This sensitive question cannot be decided by any court, not even the highest courts exercising their writ jurisdictions. The rationale is to centralize and standardize the process, protecting it from regional interpretations or prolonged court battles, and ensuring the final word rests with the executive branch of the Union.
So the central government is the sole arbitrator of this life-altering fact. Okay, finally, we have deprivation. This is the compulsory, punitive loss of citizenship enforced by the government.
Deprivation is a form of compulsory termination. It's a punitive measure enforced by an order of the government of India. It happens when the government is satisfied that the citizen has acted against the state's interest or, acquired citizenship illegitimately in the first place.
What are the primary grounds for deprivation?
The sources mention 2 major grounds. First, if citizenship was acquired by fraud, false representation, or concealing any material fact. And second, if the person has shown disloyalty or disaffection towards the Constitution of India.
Which would be shown through illegal acts or explicit hostility.
Exactly.
Before we move on, let's quickly revisit OCI status. It can also be lost or canceled, right? Specifically in relation to marriage.
Yes, the 2015 rules were tightened to prevent misuse of OCI status acquired through family ties. If a person renounces their OCI status, their minor child automatically ceases to be an OCI cardholder.
And for spouses?
The central government can cancel an OCI card obtained by a spouse of an Indian citizen or OCI cardholder if, 1, the marriage is dissolved by a court, or 2, the spouse enters into another marriage before the first one is legally dissolved.
So the OCI status is fundamentally linked to the continuous viability of the relationship that established eligibility in the first place.
That's a perfect way to put it.
We turn now to the final and most recent major legislative adjustment to the 1955 Act, the Citizenship Amendment Act of 2019, the CAA. This law specifically addressed the status of certain groups of migrants who were previously, across the board, classified as illegal.
To understand the CAA, we have to look at the pre-2019 legal context. Before this amendment, any migrant who entered India without valid travel documents or overstayed their visa was uniformly categorized as an illegal migrant.
No matter where they came from or why.
Exactly. This classification applied to all groups, including those from Hindu, Sikh, Buddhist, Jain, Parsi, or Christian communities coming from Afghanistan, Pakistan, or Bangladesh.
And the key consequence of being labeled an illegal migrant was that they were barred from acquiring Indian citizenship through the standard routes of registration or naturalization.
That was the hard legal wall they faced. However, and this is vital to note, the government had already begun taking administrative steps to alleviate the hardships for these specific groups even before 2019.
How so?
These specific groups had already been exempted from the adverse penal consequences of 2 major laws. the Passport Act of 1920 and the Foreigners Act of 1946.
Meaning they were no longer being actively prosecuted or deported under those acts?
Correct. And then later, in 2016, the government made them eligible for long-term visas to legalize their stay in India.
So by 2019, the government had already made a distinction for these groups when it came to punishment and temporary stay. The CAA then took the final step, creating a specialized path for them to acquire citizenship itself.
That is the precise function of the CAA. The Citizenship Amendment Act 2019, which came into effect on 10 January 2020, amended the 1955 Act to provide a special provision for Indian citizenship, specifically for those 6 communities coming from those 3 named countries.
And what are the defining legal parameters of the CAA?
The most defining feature is the cutoff date. The amendment applies exclusively to migrants from those 6 communities from Afghanistan, Pakistan, or Bangladesh who entered India on or before 31 December 2014.
So if they entered after that date, on January 1st, 2015, this provision does not apply to them.
It does not.
And what is the mechanism by which they transition from being long-term visa holders to full citizens under the CAA?
The Act states that the central government, or an authority it specifies, shall grant the certificate of registration or naturalization to these individuals. This is subject to specific conditions and the manner prescribed by the rules formulated under the Act.
So essentially, the CAA functions by legally removing the classification of illegal migrant for this specific time-bound group. It allows them to proceed towards citizenship under newly tailored rules, bypassing the statutory bar that applied to all other illegal migrants.
This really raises an important question. When we look back at the entire legal framework of Indian citizenship, what stands out is this careful balance. A balance between the foundational principles that were established in 1950 and the necessary flexibility Parliament has had to exercise to address these complex and often painful national issues.
The evolution is so clear. You start with the constitutional focus on domicile and the immediate, desperate needs of partition. Then you see the law tighten birthright citizenship requirements. Then it has to manage geopolitical fallout through things like the Assam Accord. Then it engages the global diaspora with the OCI cardholder status. And finally, it responds to specific humanitarian concerns with the CAA.
Absolutely. And I think the key takeaway, if you're the learner here, is that Indian citizenship law is defined by 2 immovable features. First, its unitary nature. It rejects state citizenship, it rejects state domicile, all in favor of national unity and equality of rights across the country.
Insane.
It's continuous, dynamic evolution, which means you have to constantly examine the changes to the 1955 Act alongside those foundational constitutional provisions. It's a perpetually moving target that really reflects the nation's political journey.
So what does this all mean? We started by examining this sharp legal distinction between a citizen with full civil rights and an alien facing fundamental limitations. A distinction so sharp it even creates the category of the enemy alien, who can be stripped of crucial procedural protections. And this status can even apply to a citizen who just associates with a hostile state. Considering the fluid nature of international borders and global movement today, what historical or ongoing necessity drives the continued existence of this special legal designation? Does it represent a permanent reflection of deep national security concerns, or is it a relic of a time when global allegiances were perhaps less fluid? Is it still necessary in a world where global trade and movement are instant? Something to mull over until our next deep dive.